him.
Informed methods.
At the request of the council respondent, list is granted on 27th of April. Yes, call the list.
For pronouncement of order, chair number 1.
Writ petition is allowed, both the writ petitions.
Grateful.
Till number 2 for orders matter. Finalizing.
This is yesterday's matter, my lord. Yesterday I made a submission that the notice that the petition has become infectious. Based on that notice, my lord, now the petition is closed. I obtained the records, my lord. The order sheet also discloses, my lord. Now it is transferred
One
to.
minute, 1 minute. Let me just look at.
Where is that? Page 11, my lord.
Direction crashing the police notice dated 15/4/2023. This what is your submission?
No, it is closed, my lord. Petition is closed, my lord. It was closed on 23/10/2024.
23?
10/2024.
You mean to say that notice?
Yes, my lord. Based on the notice, my lord, now the proceedings is closed. Entire proceedings is transferred to zonal commissioner BBMP, my lord. Now they have to challenge the proceedings before, pending before the zonal commissioner.
A writ petition is filed seeking the following prayer. There is no representation on behalf of the petitioner. Learned HCDP submits that the entire proceedings are closed dated 23/10/2024. Now the matter is pending before the zonal commissioner.
Zonal commissioner BBMP.
BBMP. Considering the said submission, the writ petition is, the submission is taken on record, and accordingly, in the light of the said submission, the writ petition is disposed of.
Number 3. Nayak, enough for petitioner.
This is also yesterday's matter, my lord. They are seeking to stop the illegal constructions made by the sixth. They are seeking, my lord, the prayer is at page. Direction to respond number 2 to 5, authorities to stop illegal constructions made by the sixth respondent, my lord. The suit was pending before the party, between the parties, my lord, in OS number 61 of 23.
OS number?
61 of 23. Since there is no interim order granted by the civil court, my lord, they approached the authorities and, my lord, they made this representation.
The present writ petition is filed seeking the following relief. By way of this writ petition, the petitioner is seeking a direction to the second respondent, that is the chief executive officer, circle inspector, panchayat development officer, the secretary, and also to the private respondent, not to stop the illegal constructions. It is submitted with the land council for the no representation on behalf of the petitioner. Learned HCGP submits that in respect of the very same construction and dispute, OS number 61 of 2023 is filed, and the same is pending adjudication before the court. It is submitted that petitioner, in the light of this dispute, the petitioner can seek appropriate direction.
In paragraph 2, my lord, the petitioner himself admitted that suit is pending.
The petitioner can avail the appropriate remedy before the civil court. Accordingly, the petition is disposed of, giving liberty to the petitioner to seek appropriate remedy before the civil court. Yes.
For dismissal, till number 4. Rajendra.
In this case.
Available petitioner, liberty may be given to go to DRT. Liberty may be given to go to DRT. We'll challenge the same DRT.
14 order, my lord. 14 order.
And 14 order.
Writ petition is filed seeking the following prayer. When the matter came up for hearing, land council appearing to the petitioner. Petitioner sought time for council for the petitioner submits that petition may be granted liberty to avail the appropriate remedy before the DRT. Considering the submission of the land council to the petitioner, the writ petition is disposed of in the following manner.
Your Lordship, there was an interim order in this. Kindly.
You have not
13 days
complied, my
to-
lord.
The
You have not complied.
petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy before the DRT. The petitioner shall have the benefit of section 14 of the Limitation Act.
Till number 5. Shekhar Shetty, S. Shekhar Shetty.
This is a matter where I filed a miscellaneous application to set aside the judgment in the OA proceedings. My lords, your lordships heard us on Tuesday. There was only a regard to deposit of money 5 lakhs is the amount which is to be deposited. I will deposit 2.5 lakhs, my lords.
No, you are now again going back to the same day of 2023 in year 2026 also.
It's not a case where I've sought an interim order and misused the situation, my lords. It's a
No,
genuine.
it is not interim order. Now the court is going to go, put back you in the position where you were in 2023. And from there to now, you have not paid anything to the bank.
Well, the reason is there's an
Whatever
insurance.
is the reason, whatever you borrowed the money from the bank.
Please, my lords.
Court is not concerned with your difficulties. When you have taken the money and difficulty not from 2023 to 2026.
Only one submission, then I leave it to your lordships.
Yes.
Because what has happened is the loan, there is a theft on the hypothecated goods and there is an insurance on the said loan. Therefore, it is my request, my lords may kindly consider this.
What do you say, Mr. Vignesh?
My lord, my lord, they assailed, my lord, the order passed by the DRT on 19/6/2023. The original application allowed by the DRT and subsequent to that, my lord, they filed an MA saying that ex parte had taken place. DRT considered and shown indulgence subject to deposit 10 lakh, my lord. The matter, my lord,
What is the
restored
outstanding amount? as of-
95 lakh as in today. We filed original application 95 lakh as in today. And my lord, we filed original application. It can be found at page number 58. That point of time, 29/1/2021, my lord, it is 44 lakh 10,506.
44 now has become 99.
My lord, on filing OA date, that is on 19/9/2019, my outstanding was, my lord, 44 lakh 10,506. Now it is, my lord, 95 lakh.
It's my humble request.
No, we can't help it. Your outstanding is 99 lakhs. If you're not able to pay 5 lakhs, what is the purpose of, remanding the matter?
Be a concession, my lords.
Isn't it? Please come. The present petition is filed. Seeking the following prayer. In the case of the petitioner, that petitioner is a registered public charitable trust for the purpose of providing quality-driven education. The petitioner has borrowed the loan from the respondent bank. For purchasing equipment, furniture, and other materials as advised by the University of Mysore. The furniture material so procured was duly hypothecated to the respondent bank. The petitioner has prepaid an aggregate amount of rupees 10,42,338 towards the loan dues. The respondent bank at the time of sanction of the credit facility has obtained the insurance policy according to its lending policy from the petition number 1, thereby protecting the lending amount of rupees 40 lakhs and matching margin money contribution of 22 lakhs by the petition number 1, compensating the loss of the hypothecated items in the event of any fire, theft, and other calamities. The bank has kept the insurance policy under its safe custody. We submitted that due to financial difficulties faced by the institution, they could not repay the amount. They could not pay the EMI, and the bank has declared the asset as a non-performing asset. It is stated that without giving an opportunity to the petitioner, it has been declared as an NPA. The bank has initiated the proceedings before the Debt Recovery Tribunal in OA number 1236 of 2019 by suppression of material facts and without the knowledge of the petitioner during the COVID-19 pandemic. Then an ex parte order was passed on 29/1/2021, thereby granting a recovery certificate for a sum of rupees 44,10,506.36 with interest at 13.20% per annum. petitioners were completely unaware of the proceedings in OA. Thereafter, the petitioner has approached the DRT and filed MA number 22 of 2022, seeking to set aside the ex parte order. The tribunal, after considering all the facts and circumstances and being satisfied that there was no service of notice to the petitioners, and also considering violation of the principles of natural justice, was pleased to allow the petition by order dated 31/5/2023. However, while allowing the petition, the tribunal has imposed condition that the petition shall deposit a sum of rupees 10 lakhs and also cost of rupees 3,500 on or before 15/6/2023. And it is also made clear that the judgment would be set aside on the foregoing compliances. It is stated that the petitioner has deposited an amount of rupees 5 lakh and also deposited the cost of rupees 3,500 within the short notice given by the DRT. Further, due to paucity of funds and abrupt closure of operation of the institution, the petitioner could not secure the amount. Hence, he has come up before this court. Then counsel, appearing for the petition, submits that petition is an education institution, a charitable institution, and because of the, as they could not pull up the funds, they could not pay the amount. Hence, the order of the DRT may be modified and the matter may be remitted back to the DRT so that they'll be able to effectively contest the matter. Next, then counsel appearing for the respondent bank submits that already an order was passed in the OA. Then basing on the application filed by the petitioner, the court has considered and set aside the order on the condition that he shall pay an amount of rupees 10 lakhs. He has paid 5 lakhs, but the remaining amount is not paid. In view of the same, that order passed in the original application has attained finality as a conditional order was not complied with. It is submitted that the matter is pending before this court from the year 2023. And till now, no amounts are paid. As of now, the outstanding amount is
95 lakh, my lord.
95 lakhs. Next, having heard the counsels on either side, there is a material on record. When the matter came up on the last occasion, this court has no amount is paid from 2023, and the outstanding as on today is 95 lakhs. This court has asked and counsel the petition to deposit the amount as ordered by the court, so that this court will remand the matter to will direct the DRT to consider the case of the petitioner on the merits of the matter. It is submitted by the land counsel of the petitioner that due to the financial difficulties, they are not in a position to pay any amount. The right from 2023 till now, the petitioner has not
Not any amount, my lord. I'm just asking for a concession.
2 lakh, not in a position, they'll be able to pay 2 lakh rupees.
2.5 lakh.
2.5 lakhs. When the outstanding is 9 lakhs, okay, 95 lakhs, and already once an order was passed, and on the request of the petitioner, the same is set aside, imposing a condition, and the petitioner has not complied with that condition from the year 2023, and no interim orders are passed in this case. In these circumstances, this court do not find any reason to the petitioner requires any indulgence of this court. Accordingly, the writ petition
My
is
lord,
dismissed.
I will deposit 5 lakhs. I just sought for a concession.
Huh?
I just
The
asked.
court said you can't.
No,
Isn't it?
I will ask them to deposit 5 lakhs. It was just a request that it may be reduced to 2.5 lakhs. And I left it, kindly
And
consider.
choose to say after
No,
completing the judgment, you should have said it in the beginning.
That's why I asked your lordships that it was my request. It was only my
Sir,
request.
you would have made a submission, my lord. I would also take an instruction on that effect. My lord, we have argued the matter, this honorable court pass an order. Now he's saying that, my lord, I want.
Your
to pay the
lordships
5
on the
lakhs,
last
it's not-
occasion said you deposit 5 lakhs and we'll set it aside. It was my
But
But you have
request.
not
So come with
even
the proposal
said,
today.
no, when I said, I will not grant you, you were saying that this, you can pass orders kind of.
No, it was my request. Then I said, your lordships may pass if it's 5. I kindly. It was only my
Submitted
request.
the petition will pay 5 lakhs within 1 week from today. Within 1 week on such, immediately after payment of the amount, no further time, no payment of the amount. The court shall consider the OA as, the DRT shall consider the OA as expeditiously as
Lord,
possible.
some time limit, my lord. 2021 OA allowed.
What I'm saying, what is the
Within
time?
within 1 month. We have already reduced
The
our,
OA shall be disposed of within a period of 2 months
Have
from the
to-
date of receipt of the copy of the.
I'm
can be done.
yet to file
Within
objections.
2 months from the date of the receipt of the amount shall be paid within 1 week from the date of receipt of the copy of the order. And from that date, within 2 months, the OA shall be disposed of.
There may be a direction to produce the copy of the original application along with the annexures because they have not
No,
produced it
everything,
yet.
my lord, in fact, they have to file an application before the DRT. We'll supply. First day itself, it is their
that
element,
was-
they have to do it. We'll
Next.
wait.
Cell number 6, Shankar Narayan Bhatt for
Here
petitioner.
for petitioners. So in this case, we already deposited 10 lakhs, but auto dated.
We'll hear the matter on the merits board.
Now the due was 53 lakhs 80,000 on, as on 2024.
As on
We are
date,
ready
it is
for one-time
55
settlement. We are ready for one-time settlement if they are agree.
If you must be ready. If you're ready, you should have approached the bank long back. You will not come before the court and tell.
Lord, they
in a writ
approached
petition
in
of
the
2024.
2024 OTS was already granted in December 2000. Not made any efforts to that till date. They have enjoyed the interim orders. 55 lakhs is the outstanding as on date.
In 2 weeks, we will deposit another 5
No,
lakhs.
my lord, this is happening.
I will either you file an affidavit before this court saying that when are you going to pay the remaining entire amount, or else go before the DRT. We will not.
Lord, earlier occasions also they have made the same submissions. They've always promised they will file an
Affidavit.
affidavit. They will file an affidavit. That is the earlier occasions also they will say.
Affidavit is filed.
They have not filed it. No,
No, I'll take it up on Monday, I'll not give them a long date.
please.
If you are ready to file an undertaking affidavit with regard to the remaining amount,
Please.
I'll consider, or else you go before the DRT.
All right.
Objections also.
Huh?
Statement of objections.
Take the statement of objection, give them a copy of it, list this matter on Monday, finally.
We'll
By
go
the
through
time
it.
the petition shall come up with an undertaking affidavit,
Monday.
or else the court will pass orders on the merits of the matter.
Taken up in special.
Interim order may kindly be extended.
Interim order is extended till Monday.
Cell
Yes,
number
next.
7. Cell number 7,
Give the file.
Parameshwar.
This is a writ petition of 2025. The writ petition is filed questioning the e-auction sale notice dated 26/9/2025. The respondent is Repco Home Finance Limited in the light of the law laid down in so and so that Vishwabharati. The writ petition against the private finance company is not maintainable, and that apart, the petition has not appeared before this court. Accordingly, the writ petition is dismissed as not maintainable before this court.
Cell number 8. For orders matter, cell number 8.
And petition is at liberty to avail the appropriate remedy. Yes, 8.
First respondent.
2 and 4.
For respond number 2 and 4. I'm for the respond number 2 and 4, my lords.
Yes, where is the petitioner? No representation for the petitioner. List this matter for this.
Matter is settled because so far as the banks
No, I'll have it on Monday. If they don't come up, I'll record whatever you say.
Monday.
No representation on behalf of the petitioner. List this matter on Monday for dismissal.
Please.
Land counsel appearing for the respondent submits that the matter is settled. I'll record it on Monday.
No, not settled. They are going to be settled. The negotiations
what?
is going
They have
on.
accepted.
Let
Still
them
it is
come,
not
let
finalized.
them,
Come
let
for
them,
respondent
let them
number 1.
come, let the petitioner come. Don't say anything. No representation for dismissal on Monday. Yes, 9.
9, Sanjay U. Prabhu.
No representation for dismissal on Monday, not Monday, Tuesday. Yes, 10.
Cell number 10.
Memo for withdrawal is there. Memo is filed seeking to withdraw the writ petition with the liberty to avail the appropriate remedy. Accordingly, writ petition is dismissed, giving liberty to the petition to avail the appropriate remedy. Yes, 11.
11.
Petition has become.
In this matter, my lord, I filed this petition for general parole in the year of
Petition has
2023.
become infectious.
Infectious, I don't know
The
instructions.
writ petition is filed in the following prayer. When counsel the petitioner submits that the petition has become infectious, dismissed as infectious.
Obliged.
Yes, 12.
Bill number 12. Srivastava.
No representation for dismissal on Wednesday. Yes, 13.
Bill number 13.
For respondents. This petitioner has not completed the interim order in this case.
No representation on behalf of the petitioner. Is this matter for dismissal on Tuesday? Yes, 14.
Bill number 14. Bill number 14.
Judge has a complaint against few people also. Because advocates are coming from Bangalore and they're for a specific date.
No, my lord, this your lordship may kindly see after passing
No, no.
orders,
The-
20 dates were given, 20 dates
Uh,
adjournment.
A letter is addressed by the learned judge seeking extension of time. Already on earlier occasion also, the time is extended. Finally, finally 2 months time is granted. Finally, the time is granted till April 27th, April 30th. MC shall be disposed of. Yes, next.
Bill number 15.
Respondent number 1.
Hearing
Yes.
for petitioner in this
Memo.
case. Petition has become infructuous.
It has become infructuous.
Yes. We had asked for certain directions, my lords. We had asked for certain directions against respondent number 2, my lords. They have complied with.
They're seeking to. As the same has become infructuous,
Much
memo was taken on record and dismissed as infructuous. Yes, next.
Bill number 16.
My lords, appearing on behalf of petitioners, we have deposited the 2 lakhs amount. We just pray time due for the course of the day to pay the process.
This writ petition against Manappuram Home Finance is not maintainable before this court. I'll direct the registry to return the amount that is deposited before this court and you avail appropriate remedy. The writ petition is filed seeking the following relief. The respondent is Mrs. Manappuram Home Finance Limited. The writ petition against the respondent is not maintainable in the light of the law laid down in so and so. Accordingly, the writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy. If any amount is deposited before the court by virtue of the interim order, the same shall be returned to the petitioner.
Bill number 17.
Much
Bill number
obliged,
13.
For petitioner. So your lordships yesterday indicated, your lordships yesterday indicated, petition is not maintainable as the respondent bank is a private bank and passed on a judgment, my lords, of Phoenix Arc, which your lordships have been relying. And asked me to go to the judgment that court has been referring to. In this petition, I have one submission to make. This petition are not challenging the proceedings initiated by bank. What I'm saying is the DRT itself does not have jurisdiction because.
No, whatever it is, when the writ is not maintainable. Any of it the court can't hear, go before DRT.
The issue is this, my lords, what I'm challenging, because what happens even in civil court, my lords, when we file GMCPC.
No, please understand that. When the writ is not maintainable, question of going into all these aspects would not arise.
Here the peculiar situation is when I'm saying that under 220.
No, you have to cross the first hurdle, then the other things.
But here I cannot make DRT as a party, my lord, because I'm aggrieved with the proceedings initiated there, my lords.
Then file an application there itself.
I have filed.
Then let that be decided. If you're aggrieved by that, go to DRT.
That is the impugned order, my lords.
Go to DRT. The petitioner is so-and-so, TVS Bank India Limited. In the light of so-and-so, the writ petition is not maintainable before this court. The petition is agreed with an order passed by the DRT. The petitioner is at liberty to approach DRT. Accordingly, the petition is disposed of. Yes, 18.
Lords, I must also bring to your lordship's notice, there's an order of the civil court, an order of civil court, my lords, which has now restrained the bank from going ahead with the DRT proceedings.
Whatever it is, you have to agitate all this before the DRT, not before this court. Yes, 18.
Petition,
Yes.
may seek a short pass over, my lord, senior counsel is in other courts. Kindly, my lords.
Yes, please, madam.
which had come up.
How much time? Because afternoon it's not possible.
Please, ma'am, by 1:30.
By 1:30.
By 1.
Or anyway, the sale is on 23rd. So this time.
23rd is here, Manoj, but they have taken the position. That is the difficult.
Possession we took long time back.
We'll hear it on Wednesday.
It may passed over, Manoj, kindly, Manoj.
Not possible today. Yes.
Cell number 19, hearing on IA.
But in this matter, a lady,
Lord,
a
in this
ladyship
matter,
had
I-
on the last occasion.
Lords, this was the case where your lordships had directed the union to be implemented regarding that issue of, Lords, my learned friend is,
What
that
is that?
issue of the power station which is set up on my land.
Yes, yes.
The union is here, my lords.
So that's what, no, they're relying on that, what is that?
There's an,
Yes, this OMS memorandum issued by the Government of India, Ministry of Finance, where they have to constitute in respect of the disputes between two entities.
Please.
So you will please constitute a,
So I'll just go through and make my submission.
yes,
May-
Monday?
very well.
This is matter on Monday.
Cell number 20, Rajesh Jain.
And may I request, my lord, the registry to show my name.
The registry is directed to, where is that IA?
Lord, IA is not put up. May I pass on? a
It's already
copy?
filed.
It's already filed also.
Take that. IA is filed to implement the Union of India. And it is submitted that they have served the papers on the DSP, print the name of so-and-so.
If that application is formally allowed, my lord, I'll make out, carry
Yes,
out.
IA is
correction.
allowed.
Great. I'll carry out correction in the course of the day.
Yes. Call for that, IA copy from the register and keep it in the file. Yes. List, the registry shall reflect the name of the DSP. Shantabhushan. Yes, next.
Cell
Filing the.
number 20, Nagrajesh.
Applying for permission. Accommodation may not, sometime may not. Is, and apart from that, may not, all the annexes are in Canada, may be permitted to
This
furnish.
is matter on 7th of April. No further time.
Please.
Yes, 21.
Madam, my lord, I seek for weeks time, my lord. I seek for weeks time in this matter. Security instructions.
What
my
is,
lord.
what is this matter about?
They are seeking for further investigation, my lord. There are about, my lord, 12 cases were registered. Today morning I secured the instructions. I have
List it on,
1 week time may be granted, my lord.
list this matter on 25th.
Please, my lord.
At the request of Lancans for the petitioner.
One submission.
The respondent,
25th or 26th, I am not in the station.
list it on 30th,
Please, please,
holiday. We'll have it on 2nd of April.
second. Wait.
Yes, next.
Acha, please.
Cell number 22, 22, Pulkeshi.
It seems, my lord, the petition was dismissed for default. They filed an application seeking for recalling
And
the
again,
order.
they will not appear on this day. List this matter for dismissal
Dismissal on.
on Wednesday. Case 23.
Cell number 23, 23, CD Rajashekar.
This also for dismissal on Monday. No representation.
Cell
Case
number
24.
24,
I appear for the petitioner.
Yes.
Let's say, in this case, I have filed an application to take a paper publication.
Give the file. What is the relief in the writ petition?
The relief in the writ petition is pass of annexure A and mandamus to the state police to extend police help for complying with the order passed by the BBMP. It is like this, my lords. I have put up construction on my property and the corporation alleges that I have committed violation in putting up construction and issued notice to me to demolish the deviated portion. When I went to the property, I received some resistance and therefore I lodged a complaint with the jurisdictional police and they have issued an endorsement at annexure A. My lords may kindly see annexure A, which is in local language, and they say that it is civil in nature, we can't extend any help.
No. Who has to demolish? Whose property? Who has to demolish?
I have put up the construction.
You have to demolish.
Yes, there was a complaint against me from the neighbor that the construction is not in accordance with the sanctioned plan. All right, I will remove the deviated portion. When I went to the spot, I received resistance from unknown person whom I want to implead in this
Remove
petition.
your construction.
Yes, because a civil suit is pending filed by me for an injunction, in which suit they claimed that they have constructed the building. But the civil court did not agree with them and passed an ad interim order where there is a clear observation that the construction is being put up by me, against which they filed an appeal before this honorable court. Appeal is rejected on the ground that the construction is mine and I am the owner of the property. And therefore,
After that, what happened? After the appeal dismissed, they have carried it further.
their suit is pending. They came before this honorable court feeling aggrieved of the interim order of injunction granted by the trial court. This honorable court has confirmed the interim order passed by the trial court and dismissed the appeal.
No, at this stage, why should the police intervene?
No, in the meantime,
You can file the same application before the court also.
in the
For the
meantime,
civil suit.
in the meanwhile, they set up the corporation to say that I pull down my building. All right, if there is any deviation, I will pull it down. There is no issue regarding that. But there should be no law and order situation. That is the reason why I filed a complaint before the police. Please extend police help. And they issued annexure A saying that this is a civil matter. We can't extend any help. And the circular instruction is there issued by the Commissioner of Police that whenever the court passes an order, proper protection should be given to prevent untoward being happening in the place. And following that circular, this honorable court has also passed an order in similar circumstances.
No, is it your case that the civil court has said that the construction has to be pulled down?
No. It is Bangalore City Corporation which has taken.
That the court orders have to be complied with. That's a circular.
The court orders to be complied with, and the court has consistently held that I am putting up construction and it is my construction and all that. All right. If there is deviation, I will respect the BBMP order and pull it down, the deviated portion. But abundant caution, having regard to the background of the matter, I made a request to the jurisdictional police, please depute and send a constable to prevent untoward being happening there. This is civil matter, we can't help it. That is the endorsement at annexure A, my lords. Nothing, there is no harm in extending help. I am not asking them to do anything. I will pay for it.
No, I'm of the view that endorsement is correct. If you want to submit
Annexure,
anything
yeah.
in support of it, you please,
Annexure, my
you
lord.
can make your submission.
Pardon, my lords?
According to me, that endorsement that is given by them is correct. If you want to make any submissions and in support of your case, you can submit.
My lords may kindly turn to the circular issued
Yes,
by the commissioner
yes.
and also the order passed. It is in Kannada language, that is the problem, my lords.
You can
Annexure,
point out what is the circular. You can come to
annexure
that.
K is in Kannada.
You can read and tell the court what it is.
Annexure F, my lord, for a moment. Earlier also, annexure F, my lord, page 56.
50?
56, my lord. Earlier complaint was given, it was registered, my lord, against the persons. And the, my lord, injunction is granted against the defendant number 1 and 2, who are the accused in a crime number 78 of 22. Again, my lord, they have given complaint, my lord. Therefore, my lord, since the suit is pending, my lord, injunction order is operating, they are given an endorsement.
Okay. ನಮಗೆ ಓದಿಸಬೇಕು ಇದೆ ಕೊಡಿ.
Take the.
My lords may kindly see this. I am passing on the circular which is in English language, my lords.
Yes.
The circumstances under which the commissioner can, the police can extend help.
Yes.
And following that judgment, following that circular, this honorable court has also passed an order in similar circumstance.
What about the circular? Circular is with me. Which
Sir-
relevant part of the circular you are relying on?
Yes, my lords. Got it. 21 my lords.
21.
I'm sorry, 10.
10.
Yes.
Hmm.
When a person produces orders issued by the court,
Yes.
the station officer should insist on specific court order or direction to give police protection. If the court order can be implemented, they should be implemented scrupulously, and the court orders cannot be implemented on the ground that due to any reason, the opinion of the
So
assistant
in this
director-
case, where is a court order to pull down the structure?
It is not the court order, it is an order passed by the BBMP, which I have produced at Annexure K, my lords. Annexure K is the order.
Yes.
Annexure L, ink page 68 is the order
Yes.
of the BBMP. And it is passed under the Karnataka Municipal Corporation Act. Now, I have no other option except to demolish. There is possibility that
BMP doesn't do, if any unauthorized
if
construction-
I fail to do, they will pass an order authorizing me to deposit the amount of expenditure, and they will make arrangement after getting the clearance from their audit department. That is the procedure. Now, I will do myself. I don't trouble the BBMP to carry out that work. But my apprehension is that there may be untoward. That is the reason why I approached the court.
Where is that order you are relying on? Some order by a coordinate bench with regard to this.
Yes, my lords. Just now I passed on the memo. Along with the memo, I have produced the next document at an.
You can see that.
Yes, in page 14, my lords, along with
Yes.
the memo which I passed on to my lords. The petition is disposed of with a direction to the state to take action in accordance with law upon circular number so and so dated so and so. Here also in this case, paragraph 4 is the facts of the matter. After the decree in favor of the petitioner, it is the contention of the respondent in voice number so and so, stopping them from enjoying the fruits of the decree by permitting them to so and so cut down the trees and all that. Therefore, no prejudice would be caused if the help is extended at my cost.
Please come. The present petition is filed. Seeking the following prayer. The facts of the case are: it is the case of the petitioner that the petitioner acquired title to property bearing number 31, Khata number 144, situated at Parappana Agraha, Pekuru Hubli, Bangalore South, measuring 40 into 45, totally measuring 1,800 square feet, under a sale deed dated 25/5/1993. The mutation has also taken place in favor of the petitioner. Before the said area was handed over to the BBMP for maintenance, he obtained the building license from Honga Sandra Village Panchayat and put up construction partially. There are no sufficient funds. In the meanwhile, the said area was handed over to the BBMP for maintenance. They would muster some funds to put up further construction. At that point of time, petitioner got assistance from one Srimati Sakamma and Srimati G. Manjamma, who claimed ownership over a portion of the petitioner's property measuring 30 into 40 feet under a sale deed dated 7/1/2020, made and executed by one Sri T. Sunil. Then the petition is filed OS number 2136 of 2021, seeking permanent injunction. In the said suit, in said suit, the court has granted interim injunction restraining the defendants from interfering with the petitioner's possession and enjoyment of the suit property. That was carried in appeal, and the same was dismissed in a MFA 4216 of 2022, dated 27/6/2022. Petitioner has filed a complaint with the respondent police on 16/3/2022. The crime was registered, the same was registered as crime number 78 of 2022 against all 8 persons who are the parties to the crime. When the respondents have failed to take up investigation, that made the petitioner to file WP number 10547 of 2022, seeking a writ in the nature of mandamus to investigate and file final report. And the same was disposed of by order dated 31st May 2022. It is a case that even up to date, the charge sheet is not filed. At the instance of while the matter stood thus, at the instance of the defendants in the original suit, the BBMP issued a provisional order dated 15/3/2023 under section 248(1) of the BBMP Act to the petitioner, alleging that the petition is constructing the building without obtaining construction license plan from BBMP, and that therefore the entire construction is illegal. BBMP has called the petitioner to produce the documents, and he has appeared before the BBMP. An order was passed under section 248(2) of the BBMP Act, directing the petitioner to remove the unauthorized construction. Petitioner realized the mistake and took necessary steps to comply with the order passed by the BBMP. But again, he got resistance from the persons, from the defendants in the suit. Anticipating untoward incidents, on 1/5/2023, petitioner made a request through his advocate to the first respondent police to extend police protection for complying the orders passed by the BBMP under section 248 of the BBMP Act 2020. The respondent police did not even receive the request and acknowledge the, let alone favoring the same. Then the petitioner has approached third respondent police. The Assistant Commissioner had requested to look into the matter. He in turn forwarded the representation dated 1/5/2023 of the petitioner to the first respondent with a request to look into the matter. Again, the petitioner approached the first respondent several times, but the first respondent was reluctant to listen to the plight of the petitioner, and he was totally non-cooperative. It is stated which made the petitioner to come before this court. Learned counsel appearing for the petitioner submits that the respondent police are obligated to give protection, the security for the purpose of demolishing the structure, as there is resistance from the defendants in the suit. It is submitted that in the light of the circular issued by the Office of the Director General and Inspector General of Police dated 14/11/2018, particularly as per clause 10 of the said circular, when a person produces an order issued by the court, no station house officer should insist on specific court direction to give police protection. If the court orders can be implemented, they should be implemented scrupulously. If the court orders cannot be implemented on the ground due to any reason, opinion of the Assistant Director of Prosecutions, Deputy Director of Prosecution, legal advisor attached to the Office of the Commissioner of Police should be obtained, and according to the opinion, action should be taken. If the order cannot be implemented on the ground due to any reasons, a report should be sent to the concerned court for consideration and further orders. Relying on this, learned counsel for the petitioner submits that the respondents are obligated to grant protection for the petitioner for demolition of the said structure. he had relied on another order passed by coordinate bench of this court ended petition number 20434 of 2023 dated 8th November 2023, wherein basing on the very same circular, the court has passed an order. Our court has court has issued a direction to the station house officer to take action in accordance with the circular dated 14/11/2008 for grant of police protection to the petitioners in accordance with law. Land counsel appearing for the respondent, Learned HCGP submits that defendants have an injunction.
Yes, madam. Against injunction, my lord, against defendants, my lord, injunction is operating. The judgment which was relied by the petitioner, in that matter, my lord, the suit was decreed. In this present matter, my lord, the suit is still pending for consideration, my lord.
No. You said something. Defendants, there is an injunction that some.
No, my lord, against the defendants, my lord, earlier there was a connection.
That is a fact. Land
Yes, ma'am.
counsel.
And my lord,
Then an
the,
HCGP submits that there is an injunction against the interim injunction against the defendant, and the suit is pending considerations. And any of the rights between there is no order of the court directing the police to, but any order to pull down the structure from the civil court as such that the condition number 10 in the circular will not come to the rescue of the petitioner. It is submitted that even the judgment that is relied on by the petitioner also does not come to his rescue for the reason in the said judgment the rights of the parties are crystallized, whereas in this case the suit is still pending. In those circumstances, they have issued the impugned endorsement stating that the dispute is civil in nature and they have to approach the competent civil court. Next para. Have you heard the concerns on either side? There is the material on record. According to the petitioner, it is the case that the BBMP directed the petitioner to remove the unauthorized construction. It is a case of the defendants that they have put up the construction. And according to the petitioner has put up the construction. And when the petitioner want to remove the unauthorized construction, the respondents and the defendants are interfering with the same. Petitioner has filed a suit for injunction. An interim injunction is granted. An interim injunction has attained finality. If the defendants, in violation of the orders of the civil court, are interfering with the possession or otherwise of the petitioner, contrary to the interim orders passed, the petitioner has a remedy to go before the court and obtain necessary orders from the court. In the considered opinion of the court, the endorsement that is issued by the respondents that it is civil in dispute and they cannot grant any protection or protection as sought by the petitioner is justified, and this court finds no reasons to interfere.
and the endorsement further states, my lord, if they obtain the order from the court, my lord, we will give protection. That also says, my lord.
One correction, my lords. The order is it is not only injunction. The order of this honorable court in MFA is, I have put up construction. It is a finding.
Submitted by the land council.
It is a finding in MFA.
That both in MFA as well as in the suit, there is a observation that the petitioner has put up the construction.
And I may be given liberty to make an application in the pending suit, my lords.
The petitioner is at liberty to avail the appropriate remedy before the civil court.
Civil court.
Yes.
25. 25.
Respond in this case. The section
Liberty
14 order
we
you have
want to-
challenged.
Liberty we want to go DRT. Yes. The petition is fancying the following prayer. The matter came up and counsel for the petitioner submits that liberty may be granted to the petitioner to avail the appropriate remedy before the DRT. Accordingly, the petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy before the DRT. He'll have the benefit of section 14 of the Limitation Act.
For respondent, my lord, I have entered through caveat. My name has to be shown, my lord. BS
So and
Mahendra.
so,
BS Mahendra.
Ms. B.S. Mahendra has filed a wakalat on behalf of the bank. Yes, 26. This should be in the docket proceedings, not in the main. Yes, 26.
Section number 26, Sharath S. Gowda.
The petitioner in this case, your lordship, we had filed an application, your lordship, to replace Mysore district with Chamraj district in respondent number 3 and 4.
come to the prayer.
Issue written in it.
The respondent to consider the application filed with the petition for registration of his medical establishment within a time-bound manner. What is this?
This was disposed of. earlier,
Disposed
my
of,
lord.
your lordship, in 7/8/20.
7/8/2023.
Oh.
Thereafter, we were supposed to make applications. So since it is disposed of, the file is not put up and we are not aware whether he has filed the representation or not. If he has filed, it will be considered. In accordance with the order passed on 7/8/2023.
No, why he has come up again when it is disposed of?
Your lordship, due to the inverted tense, the name Mysore district has been placed at respondent number 3 and 4.
Oh,
Instead
you are
of,
seeking the clarification in this order.
no, your lordship, in the cost title, that's it.
That's